One more person. All right. Good afternoon, everybody. To everybody that's on Zoom and here in person. Thank you for joining us for today's A Month of Service presentation of Wills and Advanced Legal Planning, Part 1, and Why You Need It. My name is Nia Murray. I work as the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, the Earl Carl Institute, Texas Legal Services Center, the Harris County Attorney's Office, Houston Volunteer Lawyers, Harris Central Appraisal District, Harris County Tax Assessor Collector's Office, and today's presenter and partner is Lone Star Legal Aid. Is Lone Star Legal Aid. The representative here today for Lone Star Legal Aid is Ms. Jessie Campbell, and she's going to be providing all the information for you about wills and advanced legal planning. But these 9 organizations make up a month of service. And basically, a month of service is a collaboration of all of us coming together every month, offering a variety of different workshops, resources, and information to the community relative to asset building, asset protection, the maintaining of generational wealth, and community empowerment. We decided several years ago to collaborate and come together and pool a lot of our initiatives and offer as much information to the community as we possibly could relative to all of these different areas. We started several years ago in an effort to create a larger impact and to reach as many people as we possibly could, providing them with the most up-to-date and most accurate information that we can possibly get. We know that there's a lot of misinformation that's out there. We know that there's a lot of information on social media and various other resources that are not necessarily relative to the state of Texas or your particular situation. So again, we wanted to make sure that we are providing the most up-to-date and most accurate information as it relates to the laws in the state of Texas. So know that wherever you live, wherever you're joining us from, that the information is relative to your particular area as well as to the surrounding communities. It's not just for the city of Houston or for Harris County. It's relative to all areas throughout the state of Texas. So know that the information that does get provided here today is also for informational purposes only. It is not to be considered legal advice. However, we do want you to reach out to any of our legal service partners like Lone Star Legal Aid if you do find yourself in need of any civil legal assistance to apply for their services. And Jesse's going to kind of go over some of the areas that they actually offer and how to apply for their service too. But again, the information here today is for educational purposes. For the folks that are joining us on Zoom, you have the opportunity to type your question into the chat or unmute yourself at the end of the presentation to ask your questions directly. We are here live at the Kashmere Garden Public Library today, and we have a few people that are here in the audience. So if you guys do have questions as well, please just let us know at the end. And we didn't bring the note cards for them to write the questions down, did we? So is enough of you guys here, so that's no problem. So if just raise your hand, let me know what your question is, and then I'll repeat the question so that Jesse can actually answer it and everybody can actually hear it as well. For those folks that are, give the disclaimer also that we do record our sessions. We also do broadcast live on our social media platforms. So we want to try to protect your privacy as best as we possibly can. So we don't ask for any personal detail, specific information, where you live, who you're married to, who passed away, none of that kind of information. So we don't want that getting out there for everybody to have access to. So if you are joining us on our social media platforms, please feel free to type your question into the comment section. I'm monitoring that as well. And I'll ask that question at the end so that it gets addressed as well. So there's going to be a lot of information that's going to be covered here today, a lot. So by no means do we expect you guys to be the legal experts by the time we leave this presentation today. Feel free. We do offer this session every other month. Well, this is actually part 1. Part 2 will be the wills and advanced legal planning and how to draft your own will and how to draft your own TOD. But that's another session. But any of the sessions that we do offer, feel free to come back and, attend and watch or share with anybody else that that may find the information to be beneficial, or if you have some additional questions or something along those lines. Hey, Miss Betty. what else is there? I believe I went over just about everything, Jesse. If I did not remember, I'll fill in at the end. But again, we want to welcome you guys and thank you all for joining us. Oh, I also do want to say that the session that we are here in person today, we are doing in collaboration with the Northeast Coalition for Advancement and Transformation. We did a Todd clinic earlier last month out in the city gas community. So we are collaborating again with them as kind of like the follow-up to the Todd, to know that there are some other areas also that you want to make sure that you get covered as far as wills and advanced legal planning, not just necessarily a Todd. So there's other documents that you should have in place as well. So again, this is our follow-up, and we want to thank NCAT for collaborating with us, and the library for hosting us for today. So with that being said, we're going to go ahead and have Jessie introduce herself, and we're going to go ahead and get started. So, Miss Jessie.
Fantastic. All right. Good afternoon, everybody. Thank you so much for joining us. My name is Jessie Campbell. I am a directing attorney with Lone Star Legal Aid. And let me get my screen shared. And I get all my stuff on the screen so that way I can be ready to go. And for those of you, again, who are joining us online in the Zoom chat, you can go ahead and place your questions into the chat. I am pretty good about answering them as I go. So don't worry if you prefer to ask your questions verbally. I do ask you wait until the end, and then we'll have time to unmute yourself and ask the questions. Those of you who are attending in person, write them down on whatever piece of paper or whatnot you have there and hold, and then we will get the questions asked at the end. And then those of you who are attending online, someone is monitoring the chats, the messages at that point in time. And just be aware, this is a public space. It's being recorded. Do not put anything private, personal, individualized anywhere, in any space, in any context. This internet is forever, and we do not want anybody. Well, I do think that most people are actually, don't care and are not trying to do anything with anyone's personal information. There are bad actors out there then we do not want anyone sharing anyone's information in such a way that they can take your private information and do something with it and do something bad to you. So please don't do that. And also, I cannot provide legal advice today. And so which means that you do provide me with your very personal information. I can't answer your question anyways. I cannot advise you. I can only provide legal information today, which means it's just generic. I can give you an answer about what the law is. I can tell you what the law says, as it applies to everybody in any context, but I cannot tell you what it means for you in your specific situation, what your fact patterns are, what it means for your family, your property, your health. And so just be very aware of that as you kind of move forward today. In order for me to be able to do that, you have to be my client, and none of y'all are my clients. So I'm not trying to be mean. It's just the rules. And it applies to all lawyers. We can't do that unless you're our clients. So let's get going now that we've gotten that out of the way. So today we're going to be talking about legal advance planning and why you need it. Again, this is part one. Today is just going to kind of be covering the generic information about, it's a lot. Like there's a lot of, it's very hard as a lawyer who talks about these things to not see the misinformation that's out there in the street committee, as Ms. Nia talks about how she refers to it. And I like that, right? Because there's a lot of things that people say in the world that's just that's just kind of incorrect, or it's correct for that person. Like when they were doing their own advanced planning, or when their family encountered the needs that, when someone in their family passed away or they became incapacitated and they now had to kind of deal with something, that there's a lot of incorrect information or misunderstood information. And so, but there's a lot that comes into legal advanced planning and then kind of why you need it. And so hopefully we're going to give you just enough information today for you to start thinking about it, so that way you know how to be empowered when you go out, whether or not either you're able to hire an attorney, go and apply for services for an organization like mine if you qualify for services, or if you are in a situation where you do need to do it for yourself, that you at least know how to look for that extra information when you're doing that research on your own, to know what language to look for, and then be able to do it on your own in a way that you do it correctly. All right. Ooh, did all that work and then I still did not do that. So a little bit more about Lone Star Legal Aid. We are a legal aid provider. We serve 72 counties in the eastern and Gulf Coast region of Texas, the eastern third of the state of Texas, from Louisiana to the west of Texas. Basically, if you go to Austin, go one county east is who we are. And then one county north, so Waco is us. And then one county east of Dallas. So Tyler is us, and that's basically who we serve in Texas. And then Texarkana, and then 4 counties surrounding Texarkana is our service area. So pretty significant. We have 11 counties, including our Houston office is our headquarters. And then you can see our other branch offices there that we serve. So if you have family members or friends throughout that service area of Texas, that that's where you can find us if you need us. We are based on financial eligibility. I wish I can tell you exactly how much money you have to make in your household and family, but it's complicated math. You have to go through an application process for us to know whether or not you are eligible for our services. I want to say, don't assume that you don't qualify. Approximately about 25% can potentially qualify for services. So it is based on income and assets for the size of your family. Different types of law type. We are civil legal aid, so not criminal. That's public defenders, that's criminal side. So we're civil, so that's family law, bankruptcies, this puts consumer is bankruptcy, debt, housing, landlord tenant, public education, public benefits, estate planning. That's what I'm talking about today, estate planning, probate. So those are the types of things that we deal with, but no traffic tickets. Don't come to us for traffic tickets. We don't help with that. But we also don't do personal injury. So if you're in a car accident, we don't do car accidents. So, but that is the types of things that we handle. All right. We've already mentioned education only today, no legal advice. I already covered that at the very beginning. All right, so our agenda is pretty straightforward. We're going to talk about general principles, things that apply to all across. We've just got to have some basic understanding of what we need to know about estate planning. And then we're going to talk about the 3 different categories of estate planning: advanced planning, death, incapacity, and then long-term care planning. Long-term care planning is a big category. It has its own, like that itself can be its own like 1 hour, hour and a half presentation. So, but we're going to talk about that because that is advanced planning. And then we're going to talk about available resources. The majority of the time today, we're going to be talking about death, planning for death. That's what most people are worried about. That's what most people think about. But we're going to be talking about incapacity as well, planning for what that is and how we need to think about that. Right? So advanced planning versus probate. We're not going to be talking about probate today. We're going to be talking about advanced planning and estate planning. But you got to know what they are, what the differences between them. And you have to understand what probate is, because if you don't understand what probate is, you can't really do your estate planning, because one informs the other. If you don't understand what happens during probate, then it kind of makes it a little difficult about what you're trying to do in your advanced planning. So what is advanced planning? Advanced planning is preparing and planning. That's what it is. That's all it is. You're planning in before. You're planning for death, incapacity, the care of minors, children under the age of 18, minors, right? Or adults living with disabilities under our care. So these are people who are over the age of 18, but they are unable to care for themselves. And so these are people who we continue to care for who are over the age of 18. In the event of our death or incapacity. So we have to put plans in place to make sure they are cared for when we are no longer able to care for them because we have passed, or we are now incapacitated and someone has to now take care of us because we can no longer take care of ourselves, right? So we're putting plans in place for them or our long-term care, right? And putting all of those thoughts, what we want to do, into a legally binding written document. That's all advanced planning is. We are preparing. It's the before. That's all advanced planning is. Probate is the after. Probate is actually death, right? Probate is the legal process. It's the court process. Probate's actually the court process. So technically, if we're going to be like specific, right? And has a lawyer, I should be specific. Lawyers, today I kind of have a quasi in between thing, right? I don't have my full lawyer hat on. I'm not quite in full lawyer mode, but like lawyers are very, I'm old, I'm a Gen Xer. And so I remember, the Clinton impeachment process. And there was a joke at that point in time where he was like, well, it depends on what is, right? Like we can make jokes about like specific, like wording and definition, right? So technically probate is the court process after a person passes away. That's actually that's the definition of probate. But you will hear people talk about probate as the process after a person passes away. That's actually not correct, right? So, but probate is technically the court process, but you'll hear people talk about probate as the general process of anything, of the process of what to do after a person passes away. But it's technically the court process. So, so in the court process is filing an application to go to court and what happens there depends on whether or not there's a will. How that will is drafted. Is it by hand? Is it typed? Is it executed correctly? Is it self-proving? We're going to talk about what all that means, right? Right. All I think. Is there no will? That is what determines what happens during that probate court process. The ease of that, how efficient it is, how expensive it is, how long it takes, all depends on what happens, depends on whether or not there's a well-drafted, properly executed will. That's ultimately what happens in that probate process. So understanding that determines, informs the will, right? Like then you want a well-drafted, properly executed will, right? Because if you don't have a well-drafted, properly executed will, then your probate process can be completely different. So that's basically what the probate process is. That's all it is. That's essentially what the difference is. And I'm going to talk more about what the probate process is when we get into the details about the will. But that's it. That's basically what the difference is. But we are not here to talk about the probate process other than for you to understand what happens in probate when we're talking about drafting the will. So if you're here today to ask me about, hey, I have a loved one who passed away and I need to know what to do to clear title. I need to know what to do about how to, I don't have a will, or I can't find a witness, or whatever that question is going to be related to a person who's passed away. I'm not answering any of those questions today. That is not what today is, because today we're only going to be talking about before. The only thing I'm going to be talking about as it relates to the probate process is for you to understand what it means as it relates to how it impacts the drafting of the will. If you have those types of questions, please come to my wonderful friend Lisa Nelson's presentation, which is next week. Next week, right, Ms. Nia? Next week. Yes. And she will be able to answer some of those questions next week in her session, which is on clearing title. So just want to make sure that we understand that. All right. Okay. Key takeaways. Someone must do something after a person passes away. Drafting a will, having a TOD. We're going to explain what those are when we get to those sessions. Is not enough. You have to know this. You have to go do something. We have to be sure that we finish this through. We're going to do all of this conversations about preparing for death and what we need and drafting all these documents and doing all these things. It doesn't mean that that's where it ends. You still have to do something. I just talked about having to do a probate process, right? Where you have to go through a process. someone still needs to be sure that we finish. We got to make sure we finish whatever we started, and we're going to start by drafting the documents. We got to make sure we finish it. We got to make sure we do all the things at the end. So we're going to start at the end, which is someone must do something after a person passes away. That's something to speak to an attorney to be sure that we actually do finish it. So that's your first key takeaway, is be sure that we talk about something, right? It's an individual plan. I already kind of alluded to this at the very beginning, right? So we are looking at our family members, our dynamics, the type of property that's owned, who's inheriting. Do they have special needs that we need to take into consideration? Like, are they minors? Is it an adult living with disability? Are they receiving government benefits? There's a lot of factors that can impact. Just because you want someone to receive property, inherit something, does not mean that they should just get it. Sometimes you got to think about what the impact of them receiving a gift can have on their life. There's lots of reasons why you need to be thinking about how a person receives property. Your own current health conditions. So there's a lot of reasons why people get the reasons why people come and get their estate planning done. There's usually a factor that can kind of do this. Sometimes people are just thinking about it. People are pragmatic, right? Well, I've gotten to an age, it's time for me to start thinking about it, right? Like, there's a very pragmatic promoted, but sometimes people go to a doctor and they get a prognosis, they get a health, they're like, oh, I got a test done. And now I'm like, oh, I need to start thinking about something, right? So the current health condition can be precipitating decision-making, right? Long-term health condition, family history. Maybe you have a family history that, great grandpa, I heard stories about great grandpa, about the way he kind of had a funny way of talking at the end of his life, right? And then grandpa had, a diagnosis. Looks like dad is starting to show some symptoms. He's still here. He's showing some symptoms. Maybe I have that. Maybe I have that gene. I haven't gotten gene therapy. I haven't gotten any kind of testing, but maybe I have that. Maybe I need to start thinking about that, right? Realistically, science is amazing. Maybe things will change. Maybe it won't happen, right? But being realistic, being pragmatic, maybe I need to start thinking about the possibility that I carry that gene. So, right, we may need to be thinking about that as well. So we kind of think about that. So you got to think about your own individual plans. And why is that important? Because you can't just borrow your neighbor's will, right? Like, your family may look like your neighbor's family, and maybe Bob next door is really generous, and he's like, I paid for it. We have the same house. Our kids are best friends. I got a Bob Jr. You got a Jimmy Jr. I got a Susie. You got a Sally. Just borrow my will. Just copy it. It's fine. They got their own stuff. You got your own stuff. So you can't just borrow another person's will, right? So, because they're going to share things with their lawyer and think about things that they're going to disclose that they're not going to necessarily disclose to you, even though you may be very good friends and neighbors and share things along that lines. There's a lot of factors that they take into account, that even though the will may look very similar, that you're not going to necessarily take into consideration. So individual plans, individual considerations, just because it looks the same doesn't mean that you can just take a template and just use that template and automatically utilize it the same way. When to update. As soon as you turn 18 years old, you should have a will. Period and full stop. As soon as you turn 18 years old, you should have a statutory durable power of attorney and a medical power of attorney. I am a lawyer. I am Bad News Jesse. That's kind of the joke that I have. I think that as soon as you think that Murphy can show up, you should plan for Murphy to show up. The best way to keep Murphy out your door is to invite him in, right? So be prepared. And that's the way that I look at it. So as soon as you are aware that death can come, you should have all your documents in place. That's my opinion. And that's the lawyer telling you that, right? So, but otherwise, you should just, once you have your documents in place, you can check them whenever you want. So I have clients that want to look at their documents once a year. Doesn't mean you have to change them, but they'll have documents, look at that once a year. But otherwise, it's at your major life changes is when I recommend that you look at it. And that's life changes around marital status. So when you get married, divorce, widowhood. Is when you should be updating your documents. You should be updating your documents at changes in marital status, for sure. You should be updating your documents at that stage. 100%. You should also be looking at your documents and potentially updating your documents as it relates to changes in children. So when you have children, if you have your first child, change your documents, right? For sure. You need to update your documents when you have your children, when you have a child. You may or may not need to update them depending on how you wrote your will when you had your first child. Sometimes they're written in such a way that it's pretty inclusive that you may not need to update them, but definitely when you have your first child, you should also change your documents when your children start reaching the age of majority, when they turn 18, or when you should be changing that. And then sadly, in loss of children, you should be updating your documents potentially when you have to change your children. And then if you have children living with disability as they turn 18, and then if you need guardianship, something along that line. So that health changes, like I already talked about, your individual health conditions, you should be looking at your documents with the health changes, major property changes, buying house, buying cars, RVs, family heirlooms, major inheritances. Doesn't mean you always have to do something with your documents. I mean, things with titles, cars, houses, things along that lines, you should definitely be doing something because we're going to talk about that. But that's when you're going to want to be looking at your documents, making sure that you have things in place as it relates to those major property things. That's not all property, obviously, but things that are of value, you're going to want to take a look at that. Choosing your representative. All these documents have some type of person in charge, right? They're all different names, executor, power of attorney, like they have different names, but they all serve the same role. It's a person that you are picking to stand in your shoes when you are not able to make decisions for yourself. That's all they are. It's a person who is representing you when you are not able to do so. So when you are picking a person and selecting a person, you need to pick the right person. It's a hard decision. This is an emotional decision. This actually can cause a lot of delays. I've had clients where everything's ready. The whole document is written and, and we're ready to execute. The only thing left to do is select the person to stand in the shoes, to be the final decision maker. Because it is emotional. It's hard, right? It's because you're wanting to pick someone who you trust and will do what's in your best interest or has you and make those decisions. And it's not always going to be the logical choice, right? It's not always it's not always the most logical emotional choice. I make a lot of jokes in my own family. I use my family as a lot of examples. Right. I am not the oldest child. I am the youngest child in my family. I'm also the only daughter. And I joke I joke, right? Like, so you know, it, it's not always going to be the oldest child, like, right? So the joke is that so my oldest brother is not the executor of the will, right? I'm the executor of the will for my mother. And and my brother was like, when that happened, right? And brother's like, why is Jesse the executor of the will? And I'm like, well, clearly it's because I'm the favorite, right? And so and he was like, well, what? And my mom was like, no, she is not the favorite. And I'm like, yes, I am. But she's like, no. She goes, she's the lawyer. Like, Jesse's the lawyer. Like, right now, obviously, not every family has a lawyer, and you're not going to necessarily. But in her mind, like, right, she like, and this is truly the example that, like, the reason why I make the joke, right? I'm not the favorite. I am. But like, but she's like, she's the lawyer. Let the lawyer do the lawyer job, right? Like, she's going to be able to do it fast. She's going to be able to do it quickly. She understands the system. Now, obviously, not everybody has a lawyer in the family, and I'm not saying that you need to go look for the lawyer in your family, right? But sometimes it is about finding the right person. This is a job. Doing the executor work is a job. Like Nia, you're like anyone who's like watching Nia right now on the screen, she's like, yes. Nia has recently served in a role as an executor. I don't think she'll mind me saying that, right? So and I think she's actually talked about it herself in these things. Like it's a job. You are filing paperwork, you're working, you are if you're having to sell a house, you're selling a house. Like, right, you're working with a realtor, you're fixing up a house, and then you're doing the deed transfers, and then you're like, right, you gotta sell the house. Like then, if there's no house to sell, like you're working with you might be doing a garage sale, you might be dealing with family dynamics of like mediating a family settlement. Like there, it actually is potentially a lot of work depending on what's in the estate of the property, of the estate, of what needs to handle. Like if there's debt, you're paying debt. You may be negotiating debt. You may be receiving money. You may be having to collect money. What if there's money owed to the person who passed away? You might be sending bills to people, right? So there's actually work associated with it. And so sometimes it might be a gift to the family, right? To say, honey, it's not about trust. It's not about love. This is not about whether or not I love you. This is about the fact that you're going to be grieving. I'm not going to be here. You love me. You're going to have just lost your mother. You're going to have just lost your father. Please let Uncle Bob do this as a gift to you. Let him take care of you. Let him take care of this. He wants to do this. He's going to want to do this for you. So that way you, my children, can learn to have a life without mom. Right? So so this is the counselor side, right? Attorney and counsel, right? This is the counseling side, right? Like sometimes this is about picking the right person. Now it might be your children, like it might be your child, it might be your spouse, like, right? But like, because that might be the only person, right? Or that might be the right person, right? Like I am obviously my mom's child. I'm going to be the one handling it, right? But recognize like this is not always going to be about an emotional choice. It's about picking the person who can do it. So I just talk about this in the terms of an executor role. It's the same thing for statutory power of attorney. And I'm going to talk about what each role is, so that way when we get to each document, you can understand what they each do, right? Medical power of attorney is making medical decisions, right? But the medical power of attorney also is going to be the person who's going to be making end of life decisions under the advance directive, whether or not to withhold uh, decision making for to terminate life-sustaining treatment if there's no possibility of recovery and allowing a person to pass away. That's a heavy decision, right? So just know that, right? Like it's like when you're selecting a person, like what you're actually asking them to do in that role. And then so just be aware of that. Select one person, no shared authority. When we talk about these documents, what we're asking, like we're trying to avoid conflict. Like some of this is that the role of these documents is to avoid the fight. Our judges, we elect them, we have chosen them as our civil servants to stand in that role to resolve conflicts for us and help administer our estates, to help do these roles. But they're still strangers, right? Even though we have chosen them, they're our elected officials. We don't want them to be deciding these fights for us. I mean, right. I mean, come on, this is our estate. This is our probates. We don't want them deciding things for us. So please select one person. I saw this in one of my own trainings, and I thought this was the best example. Do you really want two people driving a car? You don't, right? You really only want one person driving a car. Please select one person to serve in this role in all of these documents, including your medical power of attorney. Everyone's like, oh, I want both my children to have a say. Please select one person. You do not want a judge being the final arbiter on your medical decisions. You want a family member, and it's I can't remember how someone, right off the top of my head, I can't, like right, you know in your mind that if push comes to shove, you will have a visceral gut reaction on who you want actually making final decisions, right? Pick that person when there's a push come to shove. Pick that person to be the final decision maker. There are ways that you can kind of like balance that, like you pick one for one document, get another person for another document if you feel like there's going to be a thing, and then have discussions. Explain your decisions to everybody, because when you're not around to explain it, people will create stories in their mind, and you don't want that. It will create sadness forever. But it's like, but then explain the decisions and explain to people what you would want them to do when you're not around to explain that. Like, it's like, this is what I would like you to do. This is why the will says what it says. This is what I would want in my medical decision making in these hypothetical scenarios. So that way, when they do need to make a medical decision on your behalf, when you're not able to do so, they actually will have scenarios that they can draw from to be able to make those decisions. And then have alternatives. Okay, now let's talk about death. Key takeaway: everyone needs a will, regardless of what I say after this slide. Everyone needs a will. I do not care if you have done every other alternative known to mankind. You do a Todd, you do all the other documents, everything like that. Everyone needs a will. It's better to have a will and not need it than to need a will and not have it. Period. All right. Understanding property and transfer of ownership after death. Lots of misconceptions. I've seen so many misconceptions about property, and then they convince themselves that they don't need the will. I'd rather you have a will and not need it than need a will and not have it. If you're really trying to save some money, then write your own will. Like, just go get one of these templates and write your own will and save money that way. And then again, have a will that you potentially don't need. But again, if you need one and then all of a sudden you don't have it, the amount of money and time and family conflict that can result from that is bad. It's just bad. So everyone owns personal property. I always get that. I don't have anything. Yes, you do. You have clothes. I guarantee you will not be surprised the amount of fights people have over things that are not actually worth any real dollars. Right? People care about things. They do. Sentimental personal property exists. And when people pass away, people will fight over sentimental personal property. Period. It just does. Grief shows up in interesting ways. And I feel like Nia's like sharing a story right now, but grief does show up in interesting ways, and but everyone does own personal properties. What's going to happen with that if you live in an apartment or in a facility, like an over 50 facility or residential facility or anything like that? Who's going to get your personal property? Like, what's going to happen? Is it going to go to garage sale? So what's going to happen to the money from the garage sale? Like, who's going to be responsible for that? Who's going to be allowed to go and do that? People still need to have access to that. People still need to know what to do with that, right? So everyone owns personal property. Someone has to be able to know what to be able to do with that. Titled property must go through a legal process to clearly transfer that. That's always something that means like, oh, well, the kids are going to get the property. Like that. Well, yes, there is this thing where the law does have safety nets, right? Texas does have laws where, where there's no will, that there's a presumption where, we assume that the property is going to go to somebody, right? The property doesn't just hang out, in some way. The property does go to somebody. It does get inherited by somebody, and they make an assumption. It's like if you're married and, the property is going to go to your spouse. If all your children are also your spouse's children, it's going to, so it does kind of make an assumption, but it doesn't mean that other people know that, right? And so it still has to go through a process. You're still going to have to go through probate. And remember what I said at the beginning. The ease of that process depends on whether or not you have a will. So, and so how do we know that so say that, it's the husband that passes and he's married, and we assume that all his children are the wife's children. How do we know? How do we know that all his children are his wife's children? Do you know? Right? I mean, again, bad news, Jesse. Lawyers. We don't know. Heck, what if it's the wife that passed? How do we know that all her children are the children of the spouse? She could have had a child prior to the relationship with him that is being raised by somebody else. That she could have had a secret child that she didn't tell her current spouse about. So now the court's going to have to go find this potential secret child for either spouse, right? Whoever spouse that just passed, right? So, so again, the ease of the process very much depends on whether or not there's a will. So title property still has to go through a legal process. Whether or not there's a will does depend on how quickly that process goes. So that process typically is going to be that probate process, and how quickly that probate process goes depends on whether or not there is a will. So, but like this idea that you don't have to go through this legal process, we do have to still do that. Verbal agreements are not enforceable in the state of Texas when it comes to property. And so when everyone's like, oh no, we have this agreement that when I pass, it's going to go to Susie, blah, blah, blah. Great. Just put it down, put it in writing. So that way, when we go through this court process, that it's going to be enforceable. And plus, not to mention, just because you agree something verbally, we all play the game of telephone, right? So just, just because you say something doesn't mean that that it's going to get remembered correctly down the line. And also, just because, two people say something, it doesn't mean that we all understand the same thing with each other, right? I may have heard something and been like, I walked away being like, yes, we agreed this, but the other person may have walked away thinking that they agreed to something else. Put it down in writing, make it clear, put it in the will. A co-owner of property does not automatically get the property when the other one. This is a misconception about community property. It's like, oh, just because you own property together doesn't mean that the other owner gets it. And so let's ignore the nefarious affairs and secret children for a minute, right? So community property, just because you own it together doesn't mean the spouse automatically gets it. So right. So if you're married and all of your children are the children of your spouse, yes, for the most part, your spouse will inherit, unless you do have children from a previous relationship. And then in which case your spouse actually does not inherit, your children inherit. And so even in community property. So that doesn't happen. You actually have to create your ownership in a specific way for it to automatically go to that. And that's not the default in the state of Texas. So that's a misconception based on community property, but that's not the default in the state of Texas. So last will and testament. A will is a legal document in which a person called the testator writes down what they want to happen to their property and debt, called the estate after their death, and who they want to manage that estate, known as the executor. That's all a will is. It covers probate assets only. So what is probate assets versus non-probate assets? It's easier to cover what non-probate assets are first, because it's a negative, right? It's like talking about things in the negative. Non-probate assets are property that are owned in such a way that ownership transfers to a specific person without going through that probate process, that court process, right? So remember, probate is specifically the court process. So non-probate assets are retirement accounts, IRAs, 401ks. Those are, you designate a beneficiary. You're going to go to the financial institution where these accounts are held, and you're going to designate the beneficiary. Life insurance proceeds, the account where you purchase your life insurance policy, you're going to designate the beneficiary. And payable on death accounts. Those are your banks and your credit unions. You're going to designate the beneficiary on those credit accounts. So those are going to be your three primary financial institutions. You're going to designate a beneficiary. Those are non-probate assets. The only time those become probate assets is when there's no beneficiary listed, and then they will become part of the estate, and then they will be governed by the will. They will get paid into the court, and then they will get governed by the will. So even when you have non-probate assets, even if you have so I will get some, so sometimes we'll get all I have are non-probate assets. You still need a will, right? Because you will still potentially have a non-probate asset that can potentially still show up in probate because you may have no beneficiaries listed. I currently right now have a client, year four, where the only asset in the estate is a life insurance proceed that did not have a beneficiary listed. That's the only reason why we have a probate open for this case, for this client, because there was a life insurance proceed, life insurance policy that had a missing beneficiary, and the spouse did not have, the deceased spouse did not have a will, and we are in year four looking for other potential beneficiaries for our spouse, our deceased spouse. So when I say that the length of the probate proceedings can be very lengthy and expensive, this is it comes from real practical reasons for it. And so we're hoping this is the year. We're trying to force the hearing for the court to make a determination of heirs this year. But the knock wood. Boop, boop. I mean, at some point in time, it's like there's probably no other heir. There's probably no other heir, right? So, but we're still looking. We're still looking to see if there's potential other heir. But but that's where we are looking at a potential beneficiary here. So if you have a non-probate asset, check your beneficiaries. Make sure you have beneficiaries listed. So in this particular case, by the way, it was a life insurance policy that was provided by the employer. It was the employer. So this was not one that was purchased. So check remember, these are your employers provide you benefits. And it just so happened that this was an employer provided benefit that so check those. So this wasn't malicious or anything along the way. It was just something that he forgot, that he just didn't realize it was a benefit provided by his employer. You don't know. Other ways that that show up, other ways that you can need a will and not realize that you might need inheritances. You might receive an inheritance and then all of a sudden you need a will. So anyway, so that's a non-probate, those probate assets. Joint tenancy with a right of survivorship is also a way to be a non-probate asset. So remember what I said that in this previous slide about co-owners do not automatically get the property when the other co-owner passes away. You can do that through a joint tenancy with a right of survivorship. You can create that automatic transfer of ownership. It's an agreement between two individuals that upon the death of one, the property goes to the survivor. That one you can do with financial accounts. You can also do that with real property. I always say be really careful about this. I am not a fan personally of creating joint tenancies with a right of survivorship and doing that if you already own your house. Changing it into a joint tenancy with a right of survivorship when you enter a new relationship, that might be something you may want to seriously think about before you do. But that one shows up sometimes. But that's something that you can do. You can do that, so instead of just except doing community property, you can create a joint tenancy with a right of survivorship when you purchase your property. Again, remember, that's not the standard. The standard is what I said earlier, but you can do a right of survivorship if you wish. But think about that. You cannot undo that. once you create that, you have to agree to undo it together. But you can also create a joint tenancy with a right of survivorship as well, and that creates a non-probate asset. Otherwise, everything else is a probate asset and will be governed by the will. Key takeaway assets: access to the bank account and beneficiaries are named in your non-probate assets. The biggest issue that I see for now, that being said, if you can't avoid probate, maybe let's try to avoid probate. Probate is not a difficult process. It's not you shouldn't be scared of it. Sometimes going through probate makes sense for the estate, for the client. And I will recommend that might be the way to get what is needed for the estate. We write a will and then we go through the probate process. Don't be scared of probate. A well-drafted, properly executed will makes the probate process simple. But if we don't need to go through the probate process, then let's do what we need to do to avoid the probate process if we don't need to. Why do it if you don't need to do it? But sometimes you need to do the probate process. We'll talk about that. Don't worry. But one of the things is sometimes the only reason why we need to go through the probate process is access to a bank account. So if we don't need to, if we can eliminate the need to go through probate for everything but the bank account, then let's make sure we have access to the bank account. So when we're looking about access to the bank account, you can do that through co-ownership. You can make a co-owner of the bank account. Be careful about that. Be sure that if you're making co-owners of the bank account, they're co-owners, right? That means they can have access to the monies and things like that, just like you as an owner of the bank account. So that may or may not be what you want to do. Again, I don't know your family. Don't check my judgment over yours. But if a co-owner is what makes sense for you, then make them a co-owner, or make them a payable on death account and make sure that they're named as a beneficiary. Because you want to be sure that people can pay bills. You want to make sure they can pay mortgages, pay utilities, and things like that. The average length of time to get to the probate process is around 4 months in the state of Texas. And since those bills need to get paid before you start the probate process, assuming we're going to do a probate process, people need to get access to the money in the bank accounts in order to be able to pay that, pay funeral things and things on. I do not know what the average cost of probate is. It's all very much dependent on what the probate is, what the estate's going to have and things along that line. So there's one, even if I did know how much things would cost, I would have no idea. Because I think it's very dependent on the actual estate. And the attorneys themselves and their experience that's being hired. So you're going to want to have different access to, you're just going to be sure that they have access to the bank account. So just be sure that you have that. So either joint owners and they're trusted people that they're not going to just willy-nilly come and take money out of the account and stuff like that, or make them beneficiary to the bank account, and then be able to do that. Or you have the executor be the beneficiary to the bank account, and that you trust that the executor is going to only have access, that they're going to hold the bank account and use the money just to pay the bills, and then we'll disperse the money when they finally get access to the when they finally open the probate, that they'll take the money and then disperse the money, and they're only going to be using the funds in the account to pay the bills pending opening the probate. All right, types of wills. Sorry, my clock went away. Get my clock back up. All right, types of wills. So there's 2 types of wills in the state of Texas that are allowed in the state of Texas. A holographic will, just legal language, which is a handwritten will. It's a 100% in your own handwriting. You got to take out a piece of paper, take out a pen, write it out in your own handwriting, and then sign and date it. It must be both. It must be signed and dated for it to be a valid will in the state of Texas. All right. When admitting a holographic will, you do not need witnesses for a handwritten will. All that's needed for a a handwritten will is 100% your own handwriting, signed and dated. However, when you go to court, Your Honor, I have a handwritten will. Okay, now the judge is going to require 2 witnesses to come in to testify to the handwriting. Okay, so that means, and they are disinterested witnesses. That means they have nothing to gain. They don't know you. They know you. How? So I'm in the handwriting. Right? They are not related to you. They have nothing. They have nothing to gain. They don't owe you money. They don't, right, but so these are going to be people who may have worked with you, who are friends, neighbors, things like that, right? But they can come and testify to your handwriting. Now, I don't know about you. There are very few people who are disinterested who would know my handwriting. I do have friends who I've known for a long time who probably can come and testify to my handwriting. But I don't know very many people who can probably do that. And I think those numbers are probably, depending on how old you are and what generation you are, right? I think those numbers are probably getting smaller and smaller, right? Like it can be hard to find that. It can be hard to find people who would know your handwriting. And so with that, it is optional when you're doing a handwritten will to have witnesses. So when you have witnesses, they have to be credible witnesses and they have to be over the age of 14. So which means is that you do your handwritten will, you're going to write it out all the way through, and you're going to sign and date it, and then they are going to sign and date it as witnesses. And then when you are admitting a holographic will with witnesses, then the executor will need to bring one of those witnesses to court to testify to the will, that they are going to come in and they're going to say, yes, Your Honor, I was there. That the person who passed, they said that this was their witness, that this was their handwritten will, that they signed and dated it, and I saw them sign and date that will, has their will, and so I'm testifying to them has their will, right? All right. Now, the second type of will in Texas is an attested will, and that is a will that is 100% typed. You're going to take out your computer, your typewriter, if you're so inclined. You're going to click, you're going to print it out. It's going to be 100% typed. Okay? It is required when it's 100% typed to have 2 credible witnesses over the age of 14, disinterested. Again, disinterested is that they are not related to you by blood, marriage, or adoption. They are not going to gain anything from it. They're not going to inherit. They don't owe you money. You don't owe them money. There's nothing, completely disinterested. Right. And then same with the witness on the holographic will. When it comes to court, Your Honor, I bring you an attested 100% typed will. They're going to have to bring one of those witnesses to come to court, and the judge is going to say, and they're going to be like, yes, Your Honor, I was there. I saw that the person who died, they said to me that this was their will. I saw him or her sign and date it. I was there. I signed and dated it as well. And yes, they were up their sideline until it was their will. Right. Now, what happens if their witness there's no witness, right? There's neither one of them is going to be there. It can be difficult to do that. That's where the notary comes. Someone's like, oh, you need to have it notarized and blah, blah, blah. Right. This is where there's the self-proving affidavit, right? This is what we're talking about when we're talking about the notary. You don't have to have a notary for either one of these wills. The notary only comes into play for the self-proving affidavit. The self-proving affidavit is an additional step. It's an extra part of doing the will. It's the affidavit that's signed by the testator, again, the person writing the will, the witnesses, and a notary at the same time of executing the will. You can do it for both the handwritten will and the typed will. You can do the self-proving affidavit. And then when you go to court, executor is going to come with their attorney. You have to have an attorney going to court. By the way, I think I forgot to mention that. You do have to have an attorney going to court. Your Honor, here is a self-proved will. Judge is going to look at it and be like, sounds great. We now have a will drafted, properly executed, self-proved will, no witnesses required. So when you can, you're going to want to have a self-proved will because that reduces the need for a witness. Now, here's the thing, if you're going to be drafting your own will, and we are going to talk about how to draft your own will in the next session. That's me in 2 weeks or 2 months. We're going to talk about how you can draft your own will. Not every notary will notarize a will. You can't just go to your UPS store. They will not notarize wills at the UPS store. But some banks will do it for if you bank at that bank. Some will do it and some will not. Don't call the bank, ask them if they will, if you are one of their clients or one of their customers. AMOS and our CDC, they will help you do that. So look out for that information on how to be able to do that. So, but just be aware of that. Not all notaries will be able to do that. There are specific kind of requirements for it, and so so some notaries are like no. So just be aware of that. Don't just walk in. Sorry, I'm just getting I got a weird pop up there. All right, fill in the blank wills. No. Don't do it. Just no. The law for many, many years, and still is the law in the state of Texas, that fill in the blanks are not valid. You cannot have a half handwritten will, half typed will in the state of Texas. That law is still on the books. So don't go to a big box store, pick up a fill in the blank will. Do not go online, find a fill in the blank will, and just print it and then fill in the blanks with your pen. No. So don't do that. However, that being said, there is the Supreme Court of the state of Texas, Supreme Court, state of Texas, has done a fill in the blank pro se will. There seems to be an exception for that. If you're going to use the Supreme Court, the Supreme Court of Texas, fill in the blank pro se form wills, I'm still going to tell you to put it on the computer and type in your answers and print it out so that it's 100% typed. Because that's actually the law of the state of Texas, is that it has to be 100% typed. But it does allow, if you are using the Texas State Supreme Court forms, it does allow you to have partially fill in the blank with pen. It does say that. So it does seem that the Supreme Court forms will allow you to have a partially handwritten one. I'm still advising you to type it and then print it and then do it. But no other. Do not use any other fill in the blank form in the state of Texas. Only the ones promulgated and approved by the Supreme Court of Texas. All right. Transfer on death documents. All right. So again, if you can use a transfer on death document, and I'm going to say not everybody should use the transfer on death documents, and we are going to talk about that in this last bullet point. But if you can use a transfer on death document, this is a way to bypass the probate process. A transfer on death document is a way to transfer property without going through the probate process. There's 2 types. One for real property, transfer on death deed, TOD for short. And then for a vehicle, it's a beneficiary designation of a motor vehicle. You still own the property. You can still do whatever you want with it, including sell it. But it's a way to do that. So when you will complete the property, I'm going to move something real quick because I can't see. But yes, there we go. Right. You still own the property. You can still do whatever you want. You can put a mortgage on your property. You can do home improvements. The person that you're transferring it to upon the passing doesn't own it. They can't do anything. They can't get a home equity loan. They can't do anything with it. It's not theirs. They don't own it. But it's a way to bypass the probate process. It's a kind of, if you think about it, you're transferring it. It just is not effective until you pass. And so what's really great about this is that it's a pretty minimal cost for the transfer on death deed. It's the filing fee, the recording fee. It's technically what's called a recording, but it's a filing fee. In Harris County, which is where I am, it depends on how many pages it ultimately is, but it's typically around $35. I should know this because we just did a clinic. So, but it's, and so the beneficiary designation of motor vehicle is more expensive. It's typically around $100. So that one is a little bit more that one I don't advise as much. It depends on the motor vehicle. And I just realized I'm missing a bullet point. You can also do it for your mobile homes. So the law just got, you were able to do it before if you had designated your mobile home as personal property, but now the law has been um, amended, and now it's clear that you can now also do it if you have designated your mobile home for has a real property as well. So now for your mobile homes, you can also do it. Oh, I'm so sorry because I don't have it on here. The prop the your title document for your mobile homes. For those of you who own a mobile home, you know exactly what I'm talking about. Your title document for your mobile homes, you can now declare that, and you can now there's a section on that document where you can designate your transfer on death documentation on there as well. So it used to be that you could do a right or survivorship only. Now there is a selection there's a selection radial button there for transfer on death, not for just the right of survivorship. Now you can do a transfer on death as well. So you can just now go in and refile that document with your transfer on death for those of you who are mobile home owners. So now for all three of our major things. So real property, your land and your house. For your vehicles, that will be your car. Cars, I only recommend it if you know it's going to be your last car. So I'm 49. We bought a car a couple of years ago. We did not do a motor vehicle designation for our car because we expect to buy another car. We don't think this is going to be my last car. And so I don't do it for our last car. But if you know it's your last car, and it's in good working condition, things along that lines, then you probably might want to do it for your car. But I do recommend it for like RVs and boats, things that you are that you tend to keep for a long time. People tend to keep RVs for 20, 30 years. People live in RVs. So I would probably do it for an RV if you have an RV. And then obviously for your mobile home. If you have a mobile home for either whether it's you designate it as a personal property or as real property, you can now do it for your mobile homes. And then of course, if you own the land that your mobile home sits on, you want to do it for the land that your mobile home sits on as well. So, but those are ways to be able to do that. And then when the person passes away, then you need to go for the Todd and your mobile home. You will need to file the certificate of death in where the property is located, and then for the RV for your car, you would also you just have the new title. And so these are great ways to be able to transfer property. Highly recommend it if it makes sense. So now, where does it not? Oh, I'm sorry. Transfer on death deed and the transfer on death deed. And these documents take priority over will. So be very careful of that. So if you change your mind, you need to do a new Todd. You need to do a motor vehicle beneficiary, right? So you can't just change your mind and put it into a will. So if you give your house to Sally, but you decide a Todd, but you decided you really want to give it to Bob, and you put it into a will and Bob, so Todd to Sally, then in 25, and then in 26 you decide to give your house to Bob and you put a will in Bob. In 26 you execute a will and give it to Bob. Sally gets the house. You write a will giving the house to Sally in 25, and then you do a Todd giving it to Bill in 26. Bob gets the house. So if whoever you want to have the house, it needs to be in the Todd, right? So the Todd is right. So if you change your mind, the Todd has to either get revoked or a new Todd has to get filed. So be sure that so just be aware of that. So sometimes if you think there's a possibility that you're going to be changing your mind or something like that, and every time you do it, you have to refile. You have to pay that. You have to pay that $40 every single time, right? So sometimes that's, if you're writing your own will, that's free, right? Unless you're hiring an attorney. If you're hiring an attorney, and obviously it's cost of doing the will, but but you just know that you're always kind of paying for the revocation or filing a new Todd and things along that lines. But the Todd always takes priority over a will, because a will you go to probate court. right? A will doesn't have the effect until you go to probate court and the judge looks at it and it files the order and things along that line. The TOD takes effect immediately upon death. Yes, you have to still file the death certificate and things like that, but it's effective immediately. Just because the death certificate hasn't been filed doesn't mean that it's not effective. It's effective immediately upon death. So just know that the TOD takes effect immediately. It takes priority over the will. So just kind of always be aware that is kind of there. So when does the TOD not make sense? You're not going to want to do a TOD when you have instructions. No instructions in a TOD. So what are instructions? Instructions would be things life estates. If you have, for example, your oldest child has moved in with you, has a caregiver, right? You need someone to come move in with you to help take care of things, and they've moved in with their children and they're going to school and things along that lines. And you're like, you know what? Sally has moved in with me and my 3 grandkids are living here. And I really appreciate that. I want Sally to be able to stay in this house for as long as she wants, but at a minimum until those 3 grandbabies of mine are able to graduate from high school. The school district is a good school district. I want them to have the best education that they can have. So I want those 3 grandbabies to be able to graduate from school here. So they can stay here until that young one, who's 3 years old right now, until she graduates from high school. That's an instruction. But I want all 3 of my kids to own the house equally. But when that 3rd grandbaby graduates from high school, then I want the house to get sold, and the 3 of them, and then whatever, they can sell the house, Sally can buy the house, whatever, right? Like whatever the instruction is. But the instruction is Sally can stay in that house until that 3rd grandbaby graduates from high school. That's an instruction. You cannot put that in a TOD. If you say in a TOD that those 3 children, Sally and your 2 other children, own that house equally, those 3 children own that house equally, and child who lives in California decides that she really wants to sell the house and get her portions of the proceeds, she can sue Sally to get out of the house and sell the house. Doesn't matter that Mama said that she wants all 3 kids to be able to stay in, that she wants Sally to be able to stay in that house until all 3 grandbabies graduate from high school. If you want Sally to be able to stay in that house, that has to go into a will in order for it to be enforceable. Because remember what I said, verbal agreements are not enforceable. You must go into a will in order for that to be enforceable. That has to go into a will for that to become an enforceable instruction. Or potentially a trust, depending on how we're going to write that, right? So that cannot go into a TOD. Other instructions. I want Sally replace my roof. I want Sally, we're going to sell the house. That's fine, we're selling the house. Sally's going to move out, we're going to sell the house. But Sally replaced my roof. She owes to replace my AC. She should get the first $20,000 of the sale of the proceeds. That's an instruction. That needs to go into a will. That's not enforceable. If you trust your kids, that's on you. But how are we going to enforce that? That needs to go. Things like that. If you don't trust your kids, that definitely needs to go into a will. That does not go into a TOD. Other things that you can't do that I don't recommend, multiple owners. It's definitely better to have one person own to inherit under a TOD rather than 5. And in fact, dilution can actually create a lot of problems for property ownership, for disaster relief, getting grants, it can actually create a lot of other problems along the lines. So it's actually better to not have more than 2, potentially 3 owners inheriting under a TOD. So those types of things I do recommend that you talk to an attorney about before you have like multiple people owning under a TOD, rather than doing, so TODs, wonderful, typically best for 1 to 2 people to inherit under. You can't trust, are probably not best to do under TODs. But there's kind of limitations. If you don't have a straightforward inheritance under a TOD, you probably should talk to somebody about it, is what I would probably recommend. Oh, goodness, lots of questions. Um, oh,
I'll go back over some of those, Jesse, at
oh,
the end,
okay.
so you
All
don't have
right. I
to
was like,
sit and
oh my
read
goodness, there's lots. I don't know if I can do
it.
that now. All right. Oh, I normally don't get so many so quickly. All right, trusts. Trusts are a little bit big, but I don't really cover them. But just to kind of, just so that everyone's aware, a trust is an arrangement where a person or entity called a trustee holds legal title to property for another person called the beneficiary. Many different types of trusts: living, revocable, irrevocable. Generally, I do recommend you talk to an attorney when you are before you do a trust. I don't trust gets my friend Lisa did one recently, and I was like, oh, the way she said it, I go, if I just had as good a marketing as trust gets, I think is how she phrased it. And I was like, oh yes, if only I could have as good a marketing as trust does. We are in Texas. We are not in other states. Trusts are advanced planning in other states. If you are getting your information in a national program, that's how they do advanced planning in other states. They do trusts. You don't necessarily need a trust in the state of Texas. A well-drafted, properly executed will makes the probate process go really easily in Texas. And in fact, in many ways, if you're trying to save money, a trust might not actually do it for you. It's actually really quite interesting. Like I see, I'm on the TikTok. I say that like an old person, but I do. But I have seen so many social media posts by lawyers, and I always am just like, and sometimes they're in Texas too, and it makes me angry when I see them. But like, but I see so many social media where I see what I think to be very irresponsible posts about, like, if as a lawyer, I would tell all my clients to just throw out their wills and all they need is and I would just tell them to just do the no, no. Some people need trust. That is true. Some people do need a trust, but it's your goal. What is the purpose? What is it that you're trying to accomplish? If the only reason why you want a trust is to avoid probate because you think probate is expensive, that is not a reason to need a trust. Not in Texas. A well-drafted, properly executed will, because in probate, if you have a well-drafted, properly executed will, depending on what you need in the state of Texas and what your estate is, which for most people is usually pretty straightforward for most middle-class families, and the only thing you're doing in probate is going to a hearing to get named as an executor. And then you are that's the only thing you're doing. That's the only time you're going to probate court. The only time you're showing up in court. And then you're going to file 2 pieces of paper in court. You're going to file an inventory at 9 months, and then you're going to file a closing of the estate when the estate is closed. That's it. If you have a well-drafted, properly executed will, that is all you're going to be doing in probate court for most middle-class families. The majority of the work that's done in a probate process is the work. It's the selling of the property, doing the deed, collecting the debt, paying off the bills. So all that work is outside of the probate process. You're still going to have to do all that work in a trust. You're still going to have to do all that work transferring it into a trust. You're still going to have to do all that work transferring it out of a trust. Guess who you're going to have to pay to do all that work? It's the lawyer managing that trust, the trustee doing all that work. So the only thing you're trying to do is avoid the costs of a probate. You're just moving the costs. What is the goal of the trust? So there are reasons that you need a trust. If you have a person who has special needs, who's inheriting property, sometimes having inheritances can put their benefits at risk. Some people cannot manage property on their own. Sometimes we're avoiding tax burdens where we need trust. Some people are high wealth and we need trust to be able to do that. Sometimes there's very complicated family management that we need to be looking at. Sometimes we're looking at qualifying for benefits now. where we're looking at long-term care. So there are minors inheriting property. So there are reasons why we probably do need to look at trusts. What is your goal looking for, why you think you need a trust? And so you probably should be talking to an attorney about that. So it's outside the scope for our purposes here, because again, those needs for trust can be wide and varied. And so, but ask yourself, what's the goal? If the goal is just avoiding probate, then it's probably not a reason to do a trust. A well-drafted, properly executed will is probably going to serve your needs in many instances, to be able to do that. Okay, all right. Boop, boop, boop. All right, debt survives. I'm sorry it's a misconception. I get a lot of, like, when I started getting questions about debt a lot, misconception about debt. Some creditors, depending on what's in the estate, will discharge debt. But not all, but it's not automatically that it goes away. So, but the estate, not the heirs, is responsible to pay the debt. In some instances, it may feel like the heirs are responsible for it, but it's not. Secured property, the debt still has to get paid. Otherwise, the bank's going to come and take the property. So it feels like the heirs are responsible, but it's not. It's still the estate. But if no one pays the secured property, they're going to come and take it back, right? So real property, such as so houses and cars, right? If there's a mortgage or a car loan, you got to pay it, otherwise they're going to come and take it. So mortgages and liens, someone's got to pay it. So if you have property with such loans on them, you either need to make arrangements for that, either through your life insurance or through your own estate, right? Either give instructions to the executor on how to pay for it, or let the heirs know that they're going to have to be inheriting as subject to that debt. And either the executor needs to sell the property and then pay off the debt, or whoever is inheriting the property is going to have to either secure their own financing or hopefully be able to work with the mortgage company to either assume the loan in some way. That is not something that, some of that is pretty hypothetical at this, at some juncture, right? Because sometimes mortgage company will work with you, things like that. That's a little bit outside my scope because I do the estate planning. I don't do this part of it, but it's but they have to kind of be aware that debt survives. Now, mortgage companies, traditional mortgages, as long as the mortgage is getting paid, so the executor needs to be aware of it. That's why I talked about having access to the mortgage, access to the bank account, so that they can pay the mortgage, pay the car loans so that way when the probate gets started, they can do the work that they need to do, get the mortgage paid, and then it allows the heirs to secure their financing and things along that lines, or allows them time to pay off the property. The more important thing, not more, but importantly, something to really keep in mind is a reverse mortgage. Reverse mortgages are due 6 months after the date of death. Remember what I said, mortgages, the average length of time to start a probate is around 4 months. That's not a lot of time. And so being aware that a reverse mortgage exists is really important, because if the plan is to sell the property to pay off the reverse mortgage, there's different strategies. You have to think about what strategy is going to work, right? Which is that if it's a plan is to sell the property, maybe the strategy is to do a TOD, give it to the executor with the instruction to the executor to sell the property as quickly as possible to pay off the reverse mortgage, and then with instructions to the executor to them to disperse the money according to the terms of the will, or let the executor know so that they can get the probate process started as quickly as possible. I don't know your family. You have to know what the best strategy would be for it. Probate is the only way to control things. Probate is the best way to ensure there's judge oversight. TODs don't provide oversight. You're just trusting a person. Probate, court, oversight. TOD, no court oversight. Lawyers telling you probate's the way to go for if you want oversight and control and ensuring that things are done correctly to protect your heirs. If you want to protect your heirs, you have to go with court. But there's others, but you know your family, I don't. So, but but you have to be aware that the reverse mortgage is going to be coming and if you want to protect your heirs from potential issues there, they need to be aware that that reverse mortgage is there. Disposition of remains, that's a document that names an agent to make decisions with respect to the disposition of remains. Funeral arrangements, it's basically who's going to be in charge of your funeral arrangements. You can include your instructions, information on prepaid arrangements or burial plots, and burial cremation instructions. Right. That's it on death. I told you it was going to take the most amount of time. Everything else is going to go really quickly at this point in time. Okay. Incapacity. Planning for incapacity. This is when we're no longer able to make decisions for ourselves, right? We are still alive, but we have lost our cognitive functions. Supported decision-making is an in-between document. We still have the ability to make decisions for ourselves, but we may be either starting to lose some cognitive functions or it's diminished capacity is the other language that we kind of use. So this is the in-between. So it's a document that's signed by the adult, that's us, we're the adult, that requests a supporter person to help us make decisions. It's not a power of attorney. They can't make decisions for us. This is just a document that we give to institutions, that says, hey, when I am saying that I need help, and this is the person that I would like to give permission for you to contact when I come in, that you are going to let them help me, right? And that's what they're there to do. That person owes a fiduciary duty. It's less restrictive than a guardianship, and that's what their role is. And so that's basically what it is. It's intended to be less restrictive with a guardianship. And so that way, like if someone comes into the bank saying, hey, I really would like to transfer money to this person out of the country that I don't know, the bank is going to call the supporter and say, hey, you know, Judy's here and she would like to send money to this person out of the country. Maybe you can come here and make sure that this is the right decision. She can't, Judy, no one can stop Judy, but they can make sure that someone comes in and really make sure that Judy really wants to do it, right? And help Judy make that decision. And so it's a good thing to have in between to do it. It's also something that can help children who are aging up, who again are not fully incapacitated, but who can use a little bit of support. Statutory durable power of attorney. This is a person that makes legal and financial decisions when a person's unable to do so. This is also could be effective immediately or springing. Effective immediately means that once you sign it, that person can take that copy, walk across the street, and open up a bank account immediately, right? It doesn't require an incapacity. Or it's springing, which means it's at the time of incapacity determined by a doctor. So the person goes and has a doctor appointment, doctor makes an examination, determines that there's an incapacity, there's a doctor's letter, and then now it's effective immediately. And then that's effective at the time of the doctor's examination. There's no right or wrong here. It's whatever you choose to do it. Some people will have it effective immediately, removing the need for a doctor's appointment. Some people want it to only be. If the concern is like, well, I don't want them to abuse the power, you have an agent problem. You've chosen the wrong person. It's not, if you're worried if you've given this person an immediate power, then they're going to abuse it. You need to pick a different person. Some people will choose it to have it effective immediately because they already have a supporter in place that's already doing that work. So for example, I have a power of attorney for my mom. Mine is effective immediately. Why is it effective immediately? I don't do anything for her right now except for one thing. She does not like talking to the person at the bank on the phone. If she can do whatever she needs to do in person at the bank, she will do it at the person at the bank. But if she has to call somebody, and this happened during COVID when we were in COVID, this is when my springing power of attorney became effective immediately power of attorney. She makes me call. That is it. That is the reason why I have an effective immediately power of attorney. Truth. So, but some people like to have it effective immediately because they already have a person already doing things, and it just removes a barrier instead of having one-offs here and there at different institutions here and there, they already have an effective immediately one, right? And so they like it. It makes it convenient for them to already have one. Other people, they want to have it springing. There's no right or wrong. It's just whatever makes sense for you. But these are going to be legal and financial things. It's going to be like, paying, talking to, if you have a lawsuit, helping with the lawsuit, like, right? It's whatever those types of powers will be. Medical power of attorney, just what it sounds like, medical decision making. It's only effective when you're not able to make medical decisions. Clearly, as long as you have the ability to make medical decisions, you're going to be able to make your own medical decisions. And period. So that's it. If you have made a course of decision making while you have capacity to do so, your medical power of attorney cannot override that. So for example, if you were with your doctor and you made a course of decision making about like you don't ever want to take a certain type of medication and then you lost capacity, your medical power of attorney can't override that. So as long as the doctor is aware of that. So sometimes people are worried about that, like, right. But again, if you are worried that you have an agent that will all of a sudden, as soon as you lose your capacity, will do a different course of action, you have an agent problem. You need to change it. You need to pick a different person. Key takeaways. Everyone needs a statutory power of attorney and a medical power of attorney. So that's it. That's your minimum. If you're talking about your advanced planning, what is the minimum that you need? Everyone needs a will. Better have a will and not need it than need a will and not have it. So no matter what, everyone needs a will. I hope everyone's going to walk away from this session right now and be like, all right, Miss Jessie says I need a will. Even if I think I don't need one, I'm still going to write one, right? Yes, everyone's going to write a will. So everyone needs a will, whether or not you think you need it. Be sure you have access to a bank account. That someone's going to have access to a bank account. Because that's usually the number one thing that I have people needing probate for, and that's the only asset that they need to probate for. And then statutory durable power of attorney, medical power of attorney, that's your minimum. Doesn't mean that you're not going to need anything else, but that's going to be the minimum that you need to have to be able to get by for your advanced planning. Everything else, good to have. Recommended, highly recommended, but you don't absolutely have to have it if you're going to do things on your own. But this is your minimum protection. Designation of a guardian in the event of later incapacity. We hope we do not become permanently incapacitated, but if we should, we can name who we want to serve as our permanent guardian. And so this is not dispositive, which means that the court doesn't have to name the person that's here. But if they can qualify and then the court will likely name the person that we name here. So that's what it is. They can also, just as importantly, disqualify a person. So if you are estranged from a family member, like if you have a brother that you haven't talked to in 30 years and they're dead to you for all intents and purposes, you can say, hey, my brother, Bill in California, I haven't talked to him in 30 years. I don't want him to ever serve as my guardian. And so you named your two people, and then for some reason, those two people can't serve as your guardian. And there's reasons, right? Maybe the first choice had passed away. Second person, they themselves are no longer physically able to serve as a guardian. And they're like, and they decline for whatever reason. They're like, I'm so sorry, I physically can't take care of him anymore. And your next of kin is, what was his name? Bill in California. And so the court's like, well, it looks next of kin is the brother Bill in California. It's like, oh, nope. Looks like Bill in California has been disqualified. Even though he's next of kin, Bill's not going to serve, right? So for some people, that's just as important. So you can disqualify Bill from serving as a guardian. Two types of guardians, just like the power of attorneys, right? There's a statutory durable power for legal and financial, and then there's one for medical power of attorney. That's the two types of guardians. There's the persons, which is the care and health of the ward, and estate, property, finance, and legal matters of the ward. So just like the statutory durable, just like the power of attorneys, that's the same for guardians. HIPAA release. HIPAA gets lots of news coverage all the time. HIPAA is the Health Insurance and Portability and Accountability Act. Basically, it's the protecting of your private medical information, and it cannot be shared by certain persons without express permission. It usually applies to mostly people with access to medical information, so doctors, nurses, that type of thing, anyone associated with the medical profession, but it also includes people like lawyers. Lawyers are covered by HIPAA because sometimes we get access to medical information in the course of our representation of clients. And so we cannot share that information without the express permission of our clients or our patients in the case of the medical profession. It does not apply to everybody. If you should share your medical information, I was telling Miss Nia about something earlier today. She can share that gossip with anybody if she wishes. She is not governed by HIPAA, but it's like, so not, you can, so HIPAA is only for certain people. But we do recommend that you have HIPAA for a minimum, your medical power of attorney and the person you named as your guardian, your potential guardian. You can add other people as you wish, but this it's a blanket HIPAA release, so that way all doctors can have access to, can share medical information with other doctors for your medical power of attorney. At a minimum. The ones that you give to your individual providers and things like that only applies to that individual provider. So your general GP, they can't take that. Your medical power of attorney can't take that HIPAA release from your GP and take it to a neurologist down the street and be like, oh no, you can give me that that information. That's not going to work. So you need the HIPAA release. Advanced directive to physicians, also known as a living will. This is a pretty serious document, so give it the due deference that it deserves. This is into life decision making, and so pretty serious. It covers two situations: a terminal condition, which is defined as a person is expected to pass within 6 months, even with available life-sustaining treatment. A common example of a terminal condition would be a stage 4 pancreatic cancer, would be considered a terminal condition. The other type of condition is an irreversible condition. The condition in and of itself is not terminal, but if you don't intervene with life-sustaining treatment, then it can be a terminal condition. An example would be a coma. You can live in a coma for many years. However, you have to intervene. So you would need nutrition, right? You have to feed the body. We have to be fed. So you have to intervene with nutrition as the life-sustaining treatment. So that would be an irreversible condition. So in each of these situations, and you can have a different choice for each situation, you have different options. You can stop treatment, keep me comfortable, and allow me to pass peacefully. You can use all life-sustaining treatments. Within using all life-sustaining treatments, you can have specific instructions. You can say use all life-sustaining treatments, but then there could also be a choice to not have certain types of treatments. We have had clients say, I would like you to use all life-sustaining treatments. However, if I need to be put on a respirator, I would want to be allowed to pass peacefully in that situation. So in the full context, we had a client that said they wanted to have, if they were to go into a coma, they would want all life-sustaining treatment with the exception of a respirator. If they were to be put onto a respirator, they would want to be allowed to be passed peacefully in that scenario. And so that was what was put into their advance directive. So that would be an example of how they had written their advance directive. There is a third option, which is now most advanced directives templates. If you should read this, if you should go Googling for a template for an advanced directive, would not include this. This would be something that would get written because this is not common. Most people put one of the two options in, but it is possible to write in the option that you would want the decision to be made by your medical power of attorney after confirming with a physician. You should know that all advanced directive decisions are always conferred with the medical power of attorney. There is no physician anywhere that is reading this directive and just making the decision without talking to the medical power of attorney anywhere. So be aware of that. Like, so in that respects, like the document is the document, but their doctors are always talking to the medical power of attorney. But the third option is basically putting the decision into the hands of the medical power of attorney, as opposed to the medical power of attorney using the document has the decision document. I hope that kind of makes sense. So the third option is basically saying, let the medical power of attorney make the decision, as opposed to the medical power of attorney being conferred using this document to make has the decision making document. And then in which case the medical power of attorney would be conferring. Again, on the counseling side of things, if you do go with this option, be sure that you have very thorough conversations with your medical power of attorney that you have chosen, to let them know what you would want, what decisions makings you would have with them. If you do need to, if you are a person of faith or whatever, counseling that you need, take the time to have those counseling sessions with your spiritual advisors and things along that lines. So that way offer forgiveness if that's something that you feel is necessary between you and the person that you've chosen with your medical power of attorney. And then of course, if you do the same with the alternate medical power of attorneys, so that way they are fully aware. This does not replace a hospice plan. If you go into hospice, that plan that you have made will govern. We're almost done, I promise. A declaration for mental health treatment. This is also known as a psychiatric advance directive. This is a PAD for short. Barely does not apply for most people. Only applies for those who are at risk for a history of psychiatric hospitalization. An example diagnosis for people is someone who has schizophrenia. Would be an example. Decision making in advance for psychiatric medication, convulsive therapy, and emergency mental health treatment. Unlike the other documents where I talked about, you would look at them at major life events. This document itself expires. This one has to be executed every 3 years. Long-term care planning, just so that everyone is aware, long-term care planning includes being eligible for benefits. As we are an aging population, we are living longer. And so when I talk about advanced planning, you have to think about long-term care planning, which is how do we become eligible, how are we maintaining our wealth, as well as thinking about how are we going to be taking care of our health care. And that includes residential facilities and medical care and Medicare and Medicaid to pay for residential facilities and healthcare. That is what long-term care planning is. That's what we're talking about when we think about that. And so that, and protecting our assets from creditors, including the Medicaid Estate Recovery Program, MERP or short. So that's what it is. You do need to be thinking about that as part of your advanced planning. Again, this is something that is big in and of itself, its own topic of presentation. Two things to kind of think about for that. If you think that there's a possibility that you will need to think about becoming eligible, Medicare does not cover long-term care planning. It does, but it's a very short amount of time. It's like 30 or 60 days or something. This is not something I do, but so it's like I'm not sure what it's short. It's like 30, 60 days, maybe 90. Short amount of time. And then we're looking at Medicaid. Then we're looking at going into Medicaid. And so when we're talking about protecting our property, which is what I do, we're talking about protecting property, we're looking at either an enhanced life estate, commonly known as a ladybird estate, or we're looking at a TOD, the transfer on death deed, right? We're looking at how to protect our property for our heirs. We're looking at either the ladybird estate or the TOD. And so there's that. And then we're talking about income that helps us become eligible for Medicaid. And that is a qualified income trust, commonly known as a Miller Trust. If this is something that you are concerned about, then you should speak to an attorney about that, come in and get some advice for that. And then from the advanced planning side, we can talk about it for real property and how to protect your property for your heirs as well. Okay. All right, so what's next after you've done all this planning and you drafted all these documents and things along the lines? You're going to create a list of your accounts. Not only do you have all your documents, you need to create a list of all of those accounts to your non-probate assets, right? All your life insurance policies, 401ks. You need a list of all of that. You're going to want to great, like a list of all of your digital assets, your passwords, things like that. There, a lot of attorneys, and we have our own as well, like have like this whole kind of like, you know, documents of like how to prepare, make sure that your errors are kind of ready to go, like when the time comes, which will hopefully be many, many years from now, right? And then be sure that everyone's kind of prepared for that. Where do you keep your documents? In the safe space, safety deposit box? Sure, maybe. Be aware if you put things in your safety deposit box that the person who needs to get access to it has to be both an account holder, has to be on the account, and they also have to have a key. It has to be both. Otherwise, it will require a court order, and only the executor will be allowed to get into the safety deposit box. So may or may not be a good place for it. I'm not saying no, I'm not saying yes, just depends, but you have to be sure that it's both key holder and account holder in order to be able to get access to the safety deposit box. County clerk, you can actually file your will with the county clerk, and it would be considered as good as an original copy with the county clerk. Not required. You don't have to do it, but you can do it. It is sealed. It has not become public record until after it's filed with the probate court. So you are welcome to do that, but not required. Generally, put it in a safe place. Where are your other important documents? Where's your passport? If you have a passport, social security card, birth certificates, that's usually just as good of a place as any. And then just let your executor know where all these documents are at. So that way, when the time comes, they know where they can find it. And keep it safe. Make sure it's not just hanging out. I've gotten the question about putting it in a freezer. I am always very scared of putting anything important that's a piece of paper in any place that can get wet and moist, right? So it's especially I'm here in Houston, like things. Mildew is a thing. So be aware of that. Discuss all these things with your representatives and your family. I mean, these are hard questions and hard conversations to have. Just because you're ready to talk about it doesn't mean that your family's ready to talk about it. But these are conversations that are important to have. It is a gift to the family. It is a loving gift to be able to have everyone ready, even if they are not ready to have these conversations. But they are important to have. So I appreciate everyone, the fact that y'all really are ready to do this now. So reminder of our key takeaways. Remember, something must be done after a person passes away. Be sure you speak with an attorney. And that's to speak with an attorney. Everyone needs a will, whether you need it or it's better to have a need a will and not have it than to have it. It's better to not need a will and have it than to need a will and not have it. Be sure there's access to the bank account. Everyone needs a statutory durable power of attorney and a medical power of attorney. That is your minimum protection, those 4 documents. All right, these are our helps. There's a lot. If you think you qualify for services, these are our providers. There's me, Lone Star Legal Aid. If you like me and you need help, not necessarily me, but Lone Star Legal Aid. This is us. This is how you can provide us. So the other partners and the Month of Server Partnership, Houston Volunteer Lawyers, Earl Carl Institute. All 3 of us are very similar income eligibility requirements, and so feel free to apply to all 3 of us. I'd like my partners. It's okay. My peer organizations. For those of you who do not qualify for services and you don't qualify for services and still want to hire somebody to pay an attorney to prepare your documents, the Houston Lawyer Referral Service is a service of the Houston Bar Association. You will pay for them. Some of them do offer a sliding scale, which is that they do offer a different price point depending on your ability to pay. I do not know what they are. I do not know how much they charge. I know none of that. I work for legal aid, so don't ask me about any of that. But that's the Houston Lawyer Referral Service. Last but not least is Texas Law Help. They are a service of one of our other partners, which is Texas Legal Services something. But their website is Texas Law Help, but that is a self-help site. So not only on estate planning, but they have a lot of information on there for people doing their own things. But through Texas Law Help, there actually is a there are links that you can actually draft your own power of attorneys, some other things that you can draft your own things as well. Miss Nia is going to send you an email with various links and that kind of stuff. My next presentation is going to be how to draft your own will, how to draft your own TOD. There's going to be information on how to do your own power of attorneys. There's a whole workshop on how we can help you do TODs, and that's Nia's thing. But so there's help. There's help. So we can help. I always end in a cartoon because this is a heavy topic, because who doesn't like to spend an hour and a half talking about death? But here's Miss Hen talking to her attorney that says, I want to leave all of my estate to my sister, but if she's not living, then in trust for her eggs. All right, lots of questions, and I know we're over time, but I'm happy to spend however time we need to answer all these questions that I did not answer at all. Oh, wait, it's only 2:50. We got 10 minutes.
Okay, 10 minutes. Do I still need a will if I have a TOD? What are the advantages?
Yes, you still need a will even if you have a TOD.
Okay. How do you execute a revocable living trust when the trustee dies?
Well, if the trustees died, that means there was a TOD. There was already a trust, right? I don't understand the question. If the trustee has already died, how do you execute a revocable trust? I mean, a trust has already existed.
If the trust already exists, if the trustee dies, what happens to the trust?
I don't know. I mean, in the trust, there should be a provision on how to handle a successor trustee. There should be, I don't know. That's in the trust, there should have been some type of provision about how to appoint successor trustees. That if there's not, that's a question for the person who drafted the trust.
Okay. I don't know how much into detail of this one. The questions are in context of my in-laws who live in Snyder, Texas for the past 19 years. One, they have a will, a durable power of attorney, and advanced living directive in the state of Pennsylvania. Are they acceptable in Texas?
Things, no.
Or those documents
property in
from other
Texas is
states?
governed by Texas law. So period. Property in Texas is governed by Texas law. So I cannot speak on whether or not a trust written in another state that has property in Texas in that trust applies and works well.
Can I clarify?
Whoever drafted that trust has to be sure that they were licensed in Texas, that the trust is written in a way that applies to Texas law and things like that. So, but I can't speak on what any other lawyer. I can't talk about what another lawyer might have done.
Let me try that question again, if I could.
Not without getting real specific into a whole lot of details. Just kind of keep it general.
We are going to run really close into advice. So
no. Does a will have to be crafted in Texas to be valid in Texas? That's a fundamental question. That should not be a legal interpretation. That should be pretty straightforward. Does Texas care where the document is crafted?
Where it's actually drafted? Yeah. I don't think it care where it's drafted, as long as it's drafted. I mean, as long as it's
otherwise, how would you know?
Where Texas law? Yeah, I don't think it care where you wrote it, as long as it's complies with Texas law.
Okay.
Let's see. Okay, we asked about the average cost of probate. Does legal aid assist with finding an attorney for someone who needs to open a probate case?
If the person is eligible for service, they can apply. I can't speak on like acceptance of cases and things along that lines, but probate is a matter type that legal aid does help with. So, but I can't speak on confirmation of whether or not cases will be accepted.
You don't help find attorneys for people.
Well, I mean,
it says does It says, does legal aid assist with finding an attorney for someone who needs to open probate? And that's probably
Well,
Houston Lawyer Referral Service if they need an attorney.
well, so the way that like legal aid works, right? Like so, like Lone Star Legal Aid, Houston Volunteer Lawyers is the same way that my office works, right? But like Lone Star Legal Aid, we have staff attorneys. I work with volunteer attorneys, so does Houston Volunteer Lawyers, right? So if the staff attorney accepts your case, then they handle the case. I work with volunteer attorneys, so does Houston Volunteer Lawyers. Like we look for volunteer attorneys if we accept your case. So, but I can't speak on case acceptance, right? So if you apply and you qualify for services, then your case may get accepted for probate. Like we may accept your case. Mine and Houston Volunteer Lawyers, we look for volunteer attorneys. And so, yes, we would look for a volunteer attorney if we accept your case. But that's how we work. If we accept your case, we would look for a volunteer attorney to take for your probate case. But that's how legal aid works. But
Not just
I
referring
can't
attorneys
say
just
we're going to
because somebody
accept your
calls.
case, right? Am I answering the question? Am I answering it
Or
right?
or not just referring an attorney just because they call
Yeah.
legal aid.
But Houston Lawyer Referral
Give them
Service, if you
a lawyer.
call them, they'll give you the name of two attorneys that practice in that area of law. And so in probate, they'll give you the name of two attorneys and you can call them. They will do consultations. If you don't decide not to hire them, you can call for two other names of attorneys. Then they'll give you two more names, right? But you would have to go find an attorney. Like you would have to go meet them and decide if you want to hire them.
Okay. I have a revocable living trust for myself and my husband. Should either of us die, what are we supposed to do to report it? Once you have a trust and somebody passes, what do you do with it? Do you still have to go through probate? What do you do with it after you have a trust and somebody then
I don't
dies?
know. It's what your trust says. I don't know what your trust says. Like you wrote the trust, so it's what.
And that's primarily the reason why we don't get into a lot of trusts because they're individualized. There is no one blanket statement as it relates to trust. So
right, yeah. I mean, I don't mean to be flippant about it. I'm sorry. I'm sorry. I don't mean to be flippant about it. You wrote the trust, so whatever the purpose of your trust is, right? So you wrote the trust for whatever you did whatever you wrote your trust for, and so in some ways, so you need to review your trust, and what you intended to do with it. And so if you're not sure what it's doing and what you need to do when one passes or things like, you probably need to go back to the attorney that wrote it and ask them what happens. I can't tell you because every trust is written differently. I mean, there may be, I don't know. There may be I don't know. There may be a standard. I know what kind of trusts we do, but we don't do property transfer trusts.
Okay. Oh yeah, everything has to go through not a Todd. She's asking, do you still have to go through probate if you have a Todd and if you have a will? And that's a huge misconception because some people think because they have a will that they don't have to go through probate. There is still a process that you have to go through with a will. Can you explain that, Jesse? And I know we're not going to get into the whole probate conversation, but
yeah. So the answer is I don't know because it's a hypothetical. So you may still have to go through a probate even if you have a Todd because I don't know what else is in your estate. So, and that's really what it comes down to. A Todd only governs that piece of property. That's your Todd, right? Your estate might have other things that may still necessitate a probate. There still may be debt. There still may be collectibles, like not collectibles in the sense of you have a Lego collection. I saw a whole story about someone's Star Wars Lego collection today, but no, that's why Legos came up. But the you may have someone owes the estate money, maybe the estate was suing somebody for a personal injury or something like that, right? And so now the estate has they mean continue the lawsuit, right? It could be that there's a life insurance policy that has no beneficiary, listed, and now we have to go through a probate for that. So just because the one piece of property has a Todd, then now that piece of property doesn't have to go through probate. Doesn't mean that there's not something else in the estate that doesn't have to go through a probate proceeding. But if the only thing in the estate is the house and everything else is just personal property, right? It's just like clothing and furniture, and the family is able to kind of take care of that on their onesies, and the bank account, there's no bank account, or the bank account was also taken care of with payable on death account or something like that, and there's no reason, then there would be no probate. The thing, right? That's the reason, like, again, I'm not trying to be like, oh, I'm not answering. I don't know. I literally don't know the answer, because I don't know what's going to be the issue in the estate. Thus, the number one takeaway: you got to go talk to an attorney when the person passes away, because they're the ones that are because someone's going to have to sit down and ask all these questions. What else is there? What else is going on? So that way they can say, you're good to go. This is what we need to do. This is what else we need to do. Or that's it. All we needed to do is file the death certificate with the county. The Todd is all that needed to be done. My condolences for your loss. So I can't really answer the question that I'm trying to give you the best information I can to minimize the need for a probate, but I can't guarantee you're not going to need one.
Okay. Does a Todd work just for your home or for a lot as well?
For a lot as well. Real property, land or home.
Okay. Don't wills name? Okay. If the will names an executor, but the executor is now deceased, now what? Or can a person with durable power of attorney become the executor?
In your will, you're going to name an alternate. So in every one of these documents, you're always going to name your primary choice, and then you're going to name an alternate choice. So you can in your will, name your primary and then an alternate. If you don't name an alternate, someone else can always step up, right? Like, so if you don't name an alternate and there's still a will, someone else can choose to submit and service tribute, right? So that's basically what happens. Same thing if the executor, by the way, if you ever have, I'm not answering probate questions, but if there's ever a will and the executor chooses not to file the will and they're like, oh, nah, I didn't want to be the executor, I didn't want to do it, like, someone else can always just file the will and say, the executor didn't want to do it, I'm filing the will, I will serve as executor. The court can do that.
Okay. Let's see. One question. Okay, I'll get to that question. Okay.
I see so many probate questions. Y'all,
yeah,
all the probate questions just came to the wrong presentation. I'm sorry.
There was a question about something going on in New York. So we don't have any jurisdiction. We don't have any information about probate laws in New York. So I can't assist with that question at all.
No, you do not want me to answer questions about things in New York. I know nothing. I'll be committing all sorts of wrong things.
Let's see, where is the will clinic on wills? We're actually going to be having a will clinic in August, and I'll be sending out more information about that. And that no clinics are held online. So all of those are all in person. My dad listed me as the owner of 2 of his properties in a revocable trust made in California where he lives. Once he passes, okay, that's another question about the trust. You did check with the trust to see what the trust actually says. I had the question about should it be the same person? You were going over medical power of attorney and statutory durable power of attorney. Should they be the same person? Statutory durable power of attorney, medical power of attorney.
Oh, they don't have to. I mean, sure, they don't have. It's whatever you want. They don't have to be. They can be. They don't. My okay. Let me answer it in a better way. You should always pick who you want to be the person making the decisions for you. Period. That's kind of the way I always kind of say it. It's like ultimately at the end of the day, this is about you and who you trust making decisions for you. Now, I also don't know what's going on in your family and who's in your life, right? So if there's other considerations that you are aware of that you are thinking about, right? So when I hear a question like that, it makes me think you might have some dynamics, right? And so you've got some dynamics that you're trying to think of, that you're trying to avoid and try to appease potentially. And maybe you're not. Maybe I'm just bad news Jesse thinking that there is, right? That, like sometimes you might want to put one person in one role and another person in another role because you're trying to appease some type of dynamics, right? You're trying to avoid conflict at the end of the day, right? So if you're also trying to be like, well, I don't want someone to think that I favorites or things along that lines, you also want to be sure that you don't have a conflict, right? Some of the issues when you have different people in those roles is that if you have a person controlling a purse string and a person controlling medical decisions, if the person controlling the purse strings disagrees with the medical decisions and they're like, I don't agree with your medical decision making, so I am not going to help pay. I'm not going to agree to the payments, right? Type of thing. So trying to avoid the conflict that can potentially happen there, right? Then you're going to want to be sure that they're definitely the same person for that potential avoiding of a conflict. So I don't know if I'm really answering the question. I always think that the guiding principle should be you should want the person that you want to be making the decisions. Sometimes people will choose different people in the roles because they're trying to make sure that no one feels their feelings are hurt and they trust that everyone's going to get along and that everyone's going to work in consensus anyways, right? Like a lot of families are happy families, right? They know that everyone's going to actually be discussing with each other and they're just putting one person in charge of one thing and one person the other in charge, but they know that everyone's actually going to discuss things and everyone's going to be working in consensus, but if you think there's potential conflict and that people are going to fight, you definitely need to have one person in both roles. So that way you avoid the conflicts.
Okay. All right. And then there was another question again about let's see, I have to leave, but we watch once the replay is sent. Of course, the session is recorded. The link for the recording as well as the link for our YouTube channel will be sent out to everybody. All of the documents that Jesse went over, I have a template for all of those documents with instructions of how to fill them out. All of those are going to be sent out. All the list of the different resources that she made are listed with the contact information. All of that will be sent out to you all as well. Let's see. Do you have to go through probate if you have trust? Depends on what's in the trust. So we already went over that question. That will be instructed there. Was there anybody here in person that had questions that you wanted to have addressed? Yes, ma'am. The Todd. Yes, there is a fillable form for a Todd. You have to take it to the county clerk. The Todd has to be filed in the county register of deeds office, wherever the property is actually located. They submit a transfer on death, what do you call it, an affidavit of death that gets filed with the county clerk's office, and the property transfers. That's it. Yep, that's it. Yes, ma'am. Your Todd? Oh, it's already been filed. So we'll get into that afterwards too, because because you should have received your copy already. But okay. Well, no, it's only been a couple of weeks since then. So it's only been a couple of weeks, so you may not have gotten it back yet. Were there any other questions? Anything else? Nope. All right. Part 2 next week. What happens after probate? That session is next week. Inherited property, how to clear a title, other probate concerns, for deferred property taxes. If somebody had gotten a tax deferral, what happens? You know, all of that's going to be covered next week's session at 1 p.m. That's online only. We're not be doing that one in person. But the after, this is the before, all the after is next week. So we're going to be talking about that. I'll be sending you the link for that. The on the calendar there, when you went to register for this one, you register for that one so that you'll be receiving the link as well. So that way you have to sign up for it. So that is coming up next week. Somebody had asked about protecting your property. We have a property deed fraud and scams presentation that's next Tuesday at 1 p.m. as well. That one is online. That's to help assist with protecting people against different deed scams and things that are going on, and having people, you know, take your property and steal your property, you know, right from underneath you. Yes, sir. All of that is on the calendar that's included in your packet. It's going to be on the calendar that I send out to everybody that joined on Zoom as well. So be on the lookout for that. Anything else? Am I forgetting something else? Later on this week, we got a first time home buyer education class on Saturday, in case you guys knows of anybody. If you know of any renters, we have an eviction presentation and knowing your rights on Tuesday, the 16th. For homeowners, if you have any or need any information about maintaining or adding value to your home maintenance, there is a home maintenance presentation on Wednesday, the 17th, as well as a home improvement fair that we're going to be doing on Saturday, the 27th. But again, all of that information is included on the calendar in your packet, and look for your emails to come that gives you a little bit more detail about all of those different events that we've got coming. So Jesse, without further ado, we're gonna go ahead and give everybody their time back since we are over our time frame here. If there are any other questions that you guys have, feel free to email them to me, and I'll be happy to forward them along to Jesse. Please do not discount yourself and automatically assume that you don't apply or don't qualify for legal services. Apply for Lone Star Legal Aid or any of our other legal service resources that she provided for you guys at the end of the presentation here. So, and you'll get those links. But without that being said, thank you all very much for coming this afternoon. Thank you, Jesse. And we will see y'all next time. Look for the recording to come. All right, have a good afternoon. All right.